Well, hello everybody. This is Bill O'Leary coming to you here in another video where I'm going to be focusing on business owners and the estate planning concerns that they have, at least that they should have. So, quick introduction. My name is Bill O'Leary. I'm an attorney with Legacy Planning Law Group. We do estate planning, elder law, and probate, and we're located in Jacksonville, Florida. So, business owners, look, you guys are focused on the day-to-day, the daily grind, your nose to the grindstone, and rarely do you have time to sort of come up for air and see the bigger picture. Well, this is a bigger picture. So, what are some things that you should be mindful of as good estate planning as a business owner? One, incapacity planning. Who's going to help you manage your affairs if you can't anymore? So make sure you have good, effective things like a power of attorney in place, so someone can jump in and help you manage your affairs with respect to the business and otherwise. For medical decisions, what's called a healthcare surrogate designation, healthcare proxy, and the like. Now, what about making sure that your assets are protected? Asset protection, so very important. Well, first, sort of the lowest hanging fruit. The easiest way, go get some umbrella insurance. Talk to your insurance agent about what that is. It's layered on top of your liability in your auto. But beyond that, there's some other things that you really can put in place. For example, you should not be operating your business as a sole proprietorship. Create some sort of legal entity, and we'll talk about that in a minute. But whatever entity you create, make sure you do it right. Don't get sloppy with it, and make sure that you sort of adhere to what's called the corporate formalities. You know, have that annual meeting, prepare the minutes, put it in the file, so you can show that was in fact a separate, distinct entity. Now, before getting into the couple different types, I want to focus on two different types of protection, liability protection you can get. One is called inside liability protection, and the other is outside liability protection. Inside liability protection is that you want to be protected from a liability that arises out of the inside of the legal entity or the operation of the business inside the entity. So think sort of the basic situation. Maybe an entity owns a rental real estate, okay, and there's a slip and fall. You want that lawsuit to be confined to the assets that are owned by the entity, the property, and not other assets. Outside liability protection. Here, it is getting protection for a claim that might be brought against the owner of the business, but the liability arises outside of the business and the operation of the entity. Think, get into that car accident. Here they come. Can they get basically your stock or your ownership interest? Two very important types, so let's break it down. What about a corporation? S corporation. I'm sure some of you that have a business have an S corporation. That will get you inside liability protection, will not get you outside liability protection. So you get into that car accident over here and they're successful, they can come basically take your stock. S corporation. What about an LLC? Well, we need to break it down further into two types. One is called a single member LLC. One member, one owner of the LLC, okay? That does also give you inside liability protection like an S corporation. Does not give you outside liability protection. Car accident, here they come, they can take your LLC membership interest. The other kind of LLC is called a multi-member LLC, two or more members. There you get both kinds, the inside liability protection as well as the outside liability protection, so that injured driver in that car accident getting your membership interest. They can't quite get that, but they can get what's called a charging order. It's a very sort of limited remedy that they have. So you have that outside liability protection. What if you have a business that's owned by an LLC by spouses? Great planning technique. What we can do is we can create an LLC owned by, let's say, husband and wife, okay? And it's owned by a single owner, because that's held as tenants by the entirety. We can get that maximum asset protection under a separate kind of law called tenancy by the entirety. Then what we do is we put together an operating agreement as part of the business and put a special legal provision in there to say that at the second death, that then will get transferred, the ownership interest will get transferred straight into a trust and not have to go through probate. So it's really a neat thing that we do for married couples that have an LLC. Another kind of planning you should focus on is, death planning. Make sure that you set things up so it passes smoothly, quickly, and easily. Doesn't get stuck in the probate court, which is expensive, takes a long time, and oh, by the way, if you have an operating business that is stuck in probate, that is really on the long side. And by the way, if you have a trust, which is a great way to avoid probate, make sure that you have something in place to transfer the stock or the ownership interest into the trust. Otherwise, it does no good. And then lastly, I want to touch on succession planning. So again, nose to the grindstone, come up for air, look at the long term. Is anybody going to take this business over, or are you just going to die at your desk or walk away and lock the doors behind you? Well, who's the successor going to be? Is it going to be a family member? Think about that. Is it going to be maybe a third party that will buy it? How about a key employee? Start thinking about the appropriate successor. Also, you're able to sort of distinguish out ownership and management. So you can pass on, let's say, over time ownership interest to a successor. You can retain control by retaining management rights. Then get in place that all-important buy-sell agreement. The buy-sell agreement, especially if you have two or more owners, very, very important. You can put in restrictions to say there are going to be restrictions on if you transfer this your ownership in it. I have a right of first refusal, as an example. There can be certain triggers that are in a buy-sell agreement. So let's say one of the owners will be forced to buy out the other owner if certain things happen. A death of an owner, or let's say a disability of an owner. Maybe the owner retires, or the employment is otherwise terminated, divorce, maybe a bankruptcy, that sort of thing. So the buy-sell can set out certain triggering events that are going to sort of trigger that obligation to buy the interest, where, let's say, the owner that died or is leaving the business, the remaining owner will be forced to buy it out. What are they going to use? What is the remaining owner going to use to buy out the interest? Well, a lot of times the best tool is to have life insurance, rather than relying on the surviving owner continuing to earn enough money in the business to pay out, let's say, the surviving spouse. That cannibalizes the business. Life insurance, great way, so that there's a funding mechanism in place. So, buy-sell agreement. If you'd like to know a little bit more about business owners and the estate planning considerations that are unique to them, and maybe how we can help, we'd love to talk to you. So go ahead, schedule that free 15-minute discovery phone call. Click on the link that's at the bottom of this video now. It takes you to our booking calendar. Just grab the day and time that works for you. Do like and subscribe to our YouTube channel. And if you haven't already, share it with your friends. So this is Bill O'Leary signing off for now. Go make it a great day and a better world, and we'll see you on the next video.